Criminal law, fatal offenses, involuntary manslaughter, constructive manslaughter. Constructive manslaughter is also referred to as unlawful act manslaughter. Constructive manslaughter is a form of involuntary manslaughter. An unlawful killing has taken place where the defendant lacks the mens rea of murder. There are two types of involuntary manslaughter. Constructive manslaughter exists where the defendant commits an unlawful dangerous act which results in death. Where the defendant commits a lawful act which results in death, this may amount to gross negligence manslaughter. The case of R.V. Church set out the elements of the offense. 1. There must be an unlawful act. 2. The unlawful act must be dangerous. 3. The unlawful dangerous act must cause death. Originally following R.V. Fenton, any unlawful act would suffice for constructive manslaughter even if it was only against civil law. However, this was overruled in R.V. Franklin, which established that only offenses against criminal law would suffice. All elements of the unlawful act must be present. If there is no unlawful act, there can be no conviction for constructive manslaughter, although there may possibly be liability for gross negligence manslaughter. In R.V. Lamb, 1967, two boys were playing with a revolver. There were 2 bullets in the chamber, but neither were opposite the barrel. The 2 boys believed that this meant it would not fire. One of the boys pointed the gun at the other and fired. As he pulled the trigger, the chamber turned and the gun went off, killing the boy. The other was charged with unlawful act manslaughter. He was not liable as there was no unlawful act. No assault had been committed as the victim did not believe the gun would go off, therefore he did not apprehend immediate unlawful personal violence. In R.V. Scarlett, the defendant was not liable for constructive manslaughter when he ejected an intoxicated customer from his pub. The level of force was considered reasonable, so no unlawful act was committed. In R.V. Arabakika, 1988, the defendant peered into a railway carriage at the station looking for the victim. The victim saw him and jumped out of the carriage to escape, but unfortunately was killed on the electric track. The defendant's act of looking through the window fell short of an assault, so no unlawful act was committed. R.V. Lowe, 1973, established there must be an unlawful act. An omission will not suffice. The unlawful act need not be directed at the victim. In R.V. Larkin, 1942, the assault was directed at the victim's lover, and in R.V. Mitchell, 1983, the unlawful act of battery in the form of pushing was aimed at someone in the front of the queue, whereas the victim was at the back when other members of the queue fell on her. In Attorney General Reference No. 3 of 1994, the wounding of the pregnant woman was the unlawful act for the death of the baby. The defendant was therefore liable for constructive manslaughter. The unlawful act need not be directed at a person. In R.V. Goodfellow, 1986, the defendant set fire to his house in the hope of being rehoused. He was liable for constructive manslaughter for the death of his wife, son and son's girlfriend who perished in the fire. The unlawful act must be dangerous. However, dangerous is not given its ordinary and natural meaning. The specific meaning of dangerous was given by Lord Justice Edmund Davies in R.V. Church 1965 as, the unlawful act must be such as all sober and reasonable people would inevitably recognize must subject the other person to, at least, the risk of some harm resulting therefrom, albeit not serious harm. The test is objective, concerned with what a sober and reasonable person would regard as giving rise to some harm. This is assessed as if the reasonable person were present at the time of the unlawful act and observing. The reasonable person will have only the knowledge of an observer. Any special factors which would not be apparent to an observer will not be taken into account. In R.V. Dawson and others, 1985, 3 defendants attempted to rob a petrol station. They wore masks and were armed with a pickaxe handle and replica guns. The petrol attendant was aged 60 and suffered from heart disease. He suffered a fatal heart attack. Their convictions were quashed as a reasonable person present at the time of the attack would not have known of the heart condition. In contrast, in R.V. Watson, 1989, the appellant smashed a window and broke into the house of an 87-year-old man who suffered a heart attack and died 90 minutes after the initial break-in. The Court of Appeal held that a sober and reasonable person would regard the act of the appellant as dangerous as they would have known of the age and frail condition of the victim. In R.V. Carey and others, 2006, the defendants committed a minor assault on the victim. She had a medical condition and collapsed and died when running away. The physical assault was not the cause of death. The cause of death was the running away in fear. However, that was not an act which the hypothetical sober and reasonable person would regard as subjecting her to some physical harm. Any knowledge of the defendant, including a mistaken belief, cannot be imputed to the sober and reasonable person. In R.V. Ball, 1989, the appellant got into an argument about parking with his neighbor. Things got out of hand and the appellant went and grabbed his shotgun and what he believed to be blank cartridges. He fired a shot intending to frighten her. In fact, the cartridge was live and she died from her injury. The court held that his mistaken belief could not be taken into account. 3. The unlawful dangerous act must cause death. This has been particularly problematic for the courts in relation to where a death occurs from taking drugs. The question arises as to whether those who supply such drugs can be liable for manslaughter. Where the defendant actually injects the drug to another person resulting in death, the position is quite straightforward. The defendant's unlawful act is administering a noxious thing contrary to Section 23 of the Offences Against the Person Act 1861, and this unlawful act causes death. According to R.V. Cato, the defendant is liable for manslaughter notwithstanding the fact that the victim consented to the injection. More problematic for the courts, however, is where the victim self-injects. In R.V. Dolby, it was recognized that the possession or supply of drugs did not in itself cause death, so no liability could arise. The case of R.V. Kennedy has proved particularly difficult for the courts. It was subject to 2 appeals to the Court of Appeal and an appeal to the House of Lords. It concerned the position of a person who had prepared a solution of heroin and handed it to the victim, who then injected himself. The first appeal was unsuccessful. His conviction was upheld on the grounds that he had assisted the unlawful act of the deceased in self-injecting. However, in the subsequent case of R.V. Diaz 2002, it was pointed out that it is not a crime to inject oneself. This point was followed in R.V. Richards 2002, where the conviction was quashed as it was based on the law as stated in Kennedy's first appeal. This led to Kennedy's second appeal to the Court of Appeal. However, this was also unsuccessful. The court held, following the case of R.V. Rogers 2003, that the unlawful act was his assisting in the administration of the drug, and this amounted to an offense under Section 23. Kennedy further appealed to the House of Lords. The House affirmed the decision in R.V. Diaz. It was held that it is never appropriate to convict a person of constructive manslaughter, where they supply a Class A drug to a fully informed and responsible adult who then freely and voluntarily self-administers the drug. The decision to take the drug breaks the chain of causation. At one time, it was thought that it must be shown that the defendant had the intention to frighten or harm a person or could foresee the risk of harm. This was based on an obiter statement by Lord Denning in the civil case of Gray v. Barr, 1971. However, in DPP v. Newbury, 1977, it was established that the statement had no relevance in criminal cases. Consequently, it need only be established that the defendant had the mens rea of the unlawful act committed. There is no requirement that the defendant had mens rea in relation to the ensuing death. In summary, constructive manslaughter is a form of involuntary manslaughter. It consists of an unlawful, dangerous act that causes death. All elements of the unlawful act must be established. The unlawful act need not be aimed at the victim or a person. The unlawful act must be one which a sober and reasonable person would inevitably recognize as giving rise to some harm, albeit not serious harm. The unlawful act must cause the death. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.